Sam Seder on the Majority Report. Emma Vigeland out today. Pleasure to welcome back to the program Ian Millhiser, senior correspondent at Vox. Ian, as always, great to have you here. Thanks so much for joining us. We got a big case tomorrow in front of the Supreme Court. Skrmetti, United States versus Skrmetti. Am I pronouncing that right?
I believe that's right, Skrmetti. There's the missing vowels in the man's name.
Yes, it's strange. Okay, so what does this tell us? This is like literally maybe the biggest trans case to be argued in front of the Supreme Court?
Yeah, I mean, this is probably the biggest trans rights case the Supreme Court has ever heard. I mean, they haven't heard that many trans rights cases. I think the first time they even used the word transgender in an opinion was in the 2010s. So, it's an issue that the court only recently began to confront. This is the first case that they're giving a full hearing and oral argument to that presents the constitutional question of what limits, if any, does the Constitution place on the government's ability to restrict the rights of transgender people or to target transgender people because they are trans. And it's an ugly case. The issue here is that basically, in the years that Joe Biden was in office, in the red states, there was a huge backlash against transgender people. More than half the states, all the ones with Republican governments, passed some kind of law prohibiting or at least restricting gender-affirming care for people under the age of 18. So, can a child whose doctors and psychologists say this person needs puberty blockers, they need hormone replacement treatment, this is the appropriate medical treatment for this child. Can that child get that medical treatment? Or can the state say, nope, doesn't matter what your doctors say, doesn't matter what the consensus in the medical opinion, in the medical community is, we are forbidding you from getting the treatment that your doctor prescribed.
And so, this is, I guess we got to go back. Do we go back to Bostock in terms of the way that you read this case? I mean, and I should say, you literally wrote the book on the Supreme Court, basically trampling on people's rights and not necessarily, doing as they are inclined to do rather than any type of constraints they might feel. And that was for a court that was far more, I guess, respectful of precedent than one that exists today. So let's just start with your perspective on the analysis as opposed to sort of trying to be predictive. But what Bostock, as far as I can tell from what you've written, is a case that should dictate the outcome of this.
Yeah, I mean, Bostock should at least dictate most of the justice analysis. So Bostock is a case from several years ago when two of Trump's justices, Gorsuch and Kavanaugh, were already on the court. And the question in Bostock was whether a federal law that bans sex discrimination, that's the word that the statute uses, is sex, meaning, and sex meaning are you a man or a woman, not sex meaning sexual intercourse. Whether that statute prohibits discrimination against people because of their sexual identity or because of their gender identity or because of their sexual orientation. And the court surprised a lot of people because two of the Republican justices, Chief Justice John Roberts and Neil Gorsuch, both voted in the majority. Gorsuch even wrote the opinion saying that, yes, sex discrimination does include discrimination against on the basis of sexual orientation or gender identity. And the theory there, I mean, it makes a lot of sense. If I am allowed to date Janet, but my colleague Felicia is not allowed to date Janet, then that's just sex discrimination. You're allowing a man to do something that you're not allowing a woman to do. And similarly, if I'm allowed to dress in stereotypically male clothing and identify as a man and wear male clothing and so on and so forth, present in a male fashion, and Felicia is not, that is also discrimination on the basis of sex. Again, you are treating Felicia differently because of her sex assigned at birth. One thing that Bostock established is that when the law refers to sex, it means sex assigned at birth and not gender identity. But even with that narrow definition, the concept of sex discrimination is still capacious enough to include sexual orientation or gender identity. And so, okay,
and we should just say this is based on the Title VII of the Civil Rights Act. Is that it? I mean, is it like this is all of these determinations. The law that they're operating under is part of the Civil Rights Act from 1965, 68. I can't remember.
64. That's
64.
That's right.
And so what they're doing is interpreting, this element of it. At what point does the idea of the person's sex, granted as assigned at birth, come into play as to whether someone has a right to do something or not? And basically, Bostock says you can't make that determination based upon sex. You just simply can't.
Yeah, and in fact, Bostock has a very sweeping holding. I mean, Bostock says it is impossible to discriminate against someone on the basis of their sexual orientation or their gender identity without also engaging in sex discrimination. And I explained the reason why. I mean, again, if I, a cisgender male, am allowed to dress in this manner and to have, to identify, carry all the baggage of being male, then why isn't someone who, was born, with female genitalia allowed to do the same? That was the holding of Bostock.
And we should be clear. This isn't a question of you conflating gender and sex. It is simply the court has determined they're going to define sex in the within this construct as what sex you were born, you were attributed with at the time of birth, like what your genitalia was at the time of birth. But it's largely irrelevant which genitalia you were assigned at birth. From a legal perspective, it's just simply that however you slice it, if you want to call this person a man and that person a woman, regardless of what mechanism you're using, if they're of different sexes, they still need to be able to have the same rights to do the same things.
That's exactly right. What Bostock said is that, we don't need to get into the complicated questions about, where the boundary is between sex assigned at birth and gender identity. We don't even need to get into the question of whether a trans woman is a man or a woman. We don't have to get into any of that. We can assume under Bostock that a trans woman is a man. And even if you make that assumption, it is still the case that men are allowed to wear women's clothing if women are allowed to wear women's clothing, because if you don't allow them to do that, you are discriminating against a person because of their sex.
Right. Okay. So just so be clear, because this, I think people can get hung up on this notion of there doesn't even have to be a determination. It's just the question is someone being prohibited by something because of how someone else perceives their sex? Yeah. I mean, that's basically
not even because of how someone else perceives their sex. I mean, Bostock was all about what you got between your legs. But Bostock was all about sex assigned at birth. And even if you take all of the Republican assumptions, even if you assume that the concept of transgender people is a scam, even if you assume that the only difference that matters is there's a gender binary and some people have penises and some people have vaginas, even if you assume all of that, it is still the case that if you discriminate against someone because they are a woman acting in a stereotypically male fashion or a man acting in a stereotypically female fashion, you are discriminating on the basis of sex.
So the idea being that if you tell trans children or adults for that matter, and even if you don't recognize them as trans, but if you tell any, let's say, girl or woman that you're not allowed to take testosterone,
Right.
even though men and boys are allowed to take testosterone, then you have basically transgressed that prohibition against discriminating based on sex.
Yes, so that's what the Skrmetti case is about. So the Skrmetti case involves many states. This case arises out of Tennessee, but many states have these laws which specifically prohibit gender-affirming care. The Tennessee law is written like particularly clear what they're up to. It says like you are not allowed to give someone a medical procedure for the purpose of allowing them to live as the gender other than their sex assigned at birth, or allowing them to like deny their sex assigned at birth. Like, I mean, it's very, very clear that the purpose of the law is to make sure that people who born with boy parts live as boys, and people born as girl parts live as girls, and there's no opportunity for any kind of crossover. Like the law is very clear what it is trying to do. And I think the only sensible way after Bostock to analyze that law is to say, well, if you say to a child who was born, whose sex assigned at birth is male, that child is allowed to take testosterone because their doctor prescribes it, but you're not going to allow a child whose sex assigned at birth was female to take testosterone because their doctor prescribes it, that's just ordinary sex discrimination. Again, we don't have to get into the metaphysical questions of like, is this child a boy or a girl? Is a trans woman a man? Is a trans woman a woman? We don't have to get into any of that. We are saying, what the Tennessee law does is it says that if you are born with a penis, you are allowed to take testosterone if your doctor prescribes it. And if you're born with a vagina, you are not. That is sex discrimination. So, clear-cut sex discrimination. And under Bostock, that should have implications.
Do we have any examples of a state banning procedures with medication that doctors find to be medically necessary, where it's almost like an off-label use, right? Like, but I guess the problem is too is that like even off-label uses, like you can't even find though. I think like that there are girls, presumably, who are prescribed testosterone, not because they're trans, but because it is found to be medically necessary for whatever, maybe they have some hormonal imbalance.
So, I mean, part of what makes this a harder case than it could be is that it is well established that states can like ban all sorts of medical procedures if they deem them dangerous.
But for everybody.
For everybody. That's right. That is the distinction. So like, the state can ban heroin. My doctor can't prescribe me heroin. There's an entire federal agency. It's called the Food and Drug Administration, whose job is to determine which drugs my doctor can prescribe and which drugs my doctor cannot prescribe for me. So like, if you have a universal ban, you can say no one can take heroin, no one can take cocaine. That's fine. If there's a particular surgery that a state believes is dangerous, then the state could say no one's allowed to have the surgery. That is allowed. What makes the Skrmetti case different is it's saying that there is one rule if your child was, born, if their sex assigned at birth was male, and there's a different rule if it is female, and that is where the Constitution kicks in. Because the rule, and it's not just Bostock. I mean, this goes back to, there's a case called U.S. v. Virginia in 1996, which says that the Constitution cast a skeptical eye on any gender-based discrimination. Doesn't matter what it is. If in any case, any law in any way draws a distinction based on sex or gender lines, that law, is subject to what is called heightened scrutiny, which means that at the very least, courts are supposed to start with the presumption that the law is unconstitutional, And the state has to give a really, 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 really good reason why this law should be allowed to exist.
Now, all cases under Title VII require the heightened scrutiny. Is that right?
Well, so the distinction here, Title VII is a statute. So like Title VII is Congress wrote a law saying there shall be no sex discrimination in employment. The rule that I was just describing is a constitutional rule.
Okay.
So like, you know, and the constitutional rule, and like this is what makes Skrmetti somewhat of a more difficult case. So the rule in Title VII after Bostock is if it's sex discrimination of any kind, forbidden in the workplace, period, cannot do it. The rule in the constitutional context is if there is sex discrimination of any kind, the law is presumptively unconstitutional. But that presumption can be overcome if the state has a really, 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 really good reason for engaging in sex discrimination. And so, like, if we have a sensible oral argument in the Skrmetti case, it'll focus on that second point. I mean, I don't think states do have a really, really good reason for banning transgender care, but if we have a sensible argument, like that's where the argument should focus tomorrow.
So in other words, there's a presumptive notion that this law passed, this ban, is both unconstitutional and also contrary to statute. But it's really just a question of how significant the state's interest in superseding, I guess, this constitutional right is. And so I guess the argument would be like, you know, how are we going to be able to tell who's a man and who's a woman if this happens, right? I mean, like, what would their arguments be? It's going to be super confusing in the bathrooms, or what?
Yeah, I mean, if you get into the, like, does the state of Tennessee have a really, really good reason for banning it? You know, if you read the briefs in the Skrmetti case, they describe two entirely different sets of facts. So, like, the briefs in favor of, you know, the pro-trans briefs just say, look, like, gender dysphoria, which is the medical term for, like, the distress people feel when their body doesn't align with their gender identity, is a real medical condition. It has very serious consequences, including potentially suicide, if people are not treated. And like the medical community has determined what the appropriate treatments are. And so we should allow people to have the treatment. That's the pro-trans rights side. The anti-side is a bunch of conspiracy theories. I mean, like, if you read Tennessee's brief, like, there's this whole section where they claim that Rachel Levine, who is a high-ranking transgender official in the Department of Health and Human Services, conspired with doctors to, like, come up with very permissive pro-trans health rules. There is an allegation in there that, like, one of the hospitals in Tennessee decided that it wanted to perform a lot of gender-affirming care because they thought they could make a lot of money off of it. And so, like, if you believe Tennessee's conspiracy theories, like, you know, we want to ban a hospital from making a whole lot of money by, you know, providing quack medical treatments is a valid thing that the state can do. The problem is that, like, I just don't believe their factual representations. You know, I think it is unlikely, you know, and if you look at who is on the side of pro-transgender, on the pro-trans side, it's the American Medical Association, the American Psychological Association, like every medical organization, every psychological, you know, the American Academy of Pediatrics, every professional organization that has a stake in this fight has said that, look, the science is good here. This is the right medical treatment. And so what it should come down to is, do you really believe that there's a global conspiracy where all of the pediatricians and all the doctors and all the psychologists got together and said, hey, I bet we could make more money if we make up these fake medical treatments and provide them to kids who say they're transgender?
I will say, I think we've probably had people on the show are more or less arguing that. I mean, I like, and so, I mean, that element of this, that if the state could prove like this whole notion of trans thing is a hoax, and it is the whole medical establishment is actually just doing this for cash. When you hear people who are lobbying and I would argue in some ways intimidating, not argue, they had bomb threats at hospitals, 5 or 6 years ago, or maybe it was less. I can't remember now. The part of the reason why they're doing this is because if the medical profession largely came out and said, actually, we have our understanding of this has changed, and it is only this type of care is only required in these, even narrower circumstances, and it's already pretty narrow.
Right.
But even these even narrower circumstances, that would be an issue within the context of the case. But you'd have to believe that it is completely just a function of people trying to do a money grab, which is, it's not like there's a lot of opportunity to make money in medicine, my understanding. This would be, this seems to be like a lot of zealotry, to make for a cash grab. Let me ask you this: is there could the plaintiffs in this case, right? This is the states who have sort of assembled to ban this care. Could they argue that it is a religious offense to, I don't know, their societies? Is there a religious argument that they could deploy in this instance?
Yeah. So the states, I'll just point out, the states are the defendants here. Like they were
the
sued.
Defendants. Okay. Okay. Yes. They put the ban. Right. Okay. Got it.
Yeah. The plaintiffs are families of transgender children who are just saying, look, we want our kid to be able to get care.
Right.
Like, so that they are the plaintiffs here. Could the state make a religion argument? The correct answer to that is no. Like there is still an establishment clause in the Constitution. And so like the government is not allowed to say like, we are banning this and our only reason for banning this is because we think God told us to ban it. Like, you have to have some reason beyond that for a law. Now, with this Supreme Court, who knows? And like that gets us to the broader issue in this case, which is, if you listen to Republicans talk about the transgender issue, if you listen to groups like the Federalist Society, like you often hear, like a phrase you'll hear often is the transgender ideology, as if belief that transgender people actually exist and are a real phenomenon, and like there actually are people who experience gender dysphoria and need a medical treatment for it. They think that is an ideology in the same way that believing in, say, trickle-down economics is an ideology. And I guess the question you have to ask is, are there 5 justices on this court who have bought into that theory? And I'm pessimistic about this case, but it is also true that Bostock happened.
Right.
So
let me ask you this. I think there's probably 2 at least that think it's an ideology. For all we know, they're literally flying a flag out in front of their house on the bay, trying to make that case. But what do you, if they were to argue or to rule essentially contrary to Bostock, like what would it be that they are just not convinced that trans people are real? I don't, like, they'll have to buy in. Is there anything else in that defendant's brief outside of like, this is all a conspiracy, it's not real, trans care is not real care because trans people aren't real? Is there anything else in there?
Well, so broadly speaking, there are 2 different ways that the Supreme Court could rule against the trans plaintiffs here. Both are bad, but one is much worse than the other one. So the merely bad way that the plaintiffs could lose in this case is that the court could say, we agree that this is gender discrimination. We agree that the state is drawing distinctions and saying that children with one set of parts can't have the same medical treatments as children with another set of parts. That's just rote sex discrimination. And then the court says, but we also think that the state's interest in like banning these particular treatments is so great, we're going to allow it anyway. That's the bad, but not the worst outcome. The worst outcome, and this is what the lower court did, this is what the Sixth Circuit did in this case, what the lower court said is they essentially, they created essentially a carve out to the ban on sex discrimination for medical procedures in which gender is relevant. It's a very difficult opinion to parse. But like, what I'm concerned about is that the court, in its zeal to rule against trans people, could wind up rolling back all of these past decisions which say that any form of gender discrimination is constitutionally suspect and like arrive at the presumption of unconstitutionality. And if they do that, it's not just the rights of transgender people who are on the chopping block. It's potentially the rights of anyone who claims that they have been discriminated against by the government because of their sex could potentially be on the chopping block.
Yeah, one is basically like chopping off the limbs of a tree, which could theoretically grow back, and the other is literally starting to chop away at the trunk of the tree. It seems like, in terms of these rights, I guess I would imagine that second part has to be pretty murky, because if the medical establishment makes the determination, this is not like we're giving birth control to biologically, or to people who can not have children or something. I'm trying to figure out like what the medical profession could have ever done that where a state could determine like this is not appropriate treatment for someone of this sex. I can't even come up with a metaphor of it. So
yeah. The broader context here, and this goes beyond the legal issues. I don't know if this is necessarily relevant to the legal issues in this case, but like the politics of it is like normally state lawmakers listen to the medical, listen to medical experts. And then, again, like states ban drugs all the time. And like they have legitimate reasons for doing so. They will sometimes ban medical procedures. But like what we want is lawmakers to make those decisions based on medical science and not based on their belief that trans people are icky.
All right, last question of this. And what about like, and we're going to talk about this vape case because I want to know in terms of like the Chevron doctrine and the FDA's, but what of the approach of like just in terms of minors? So in other words, like, well, I guess again, it's the same situation. If you're going to ban steroids for children under the age of 18, you have to do it with both boys and girls, however you want to define that. Like you can't make a distinction between the sexes unless there's some type of, I guess, medical determination that, I don't know, girls mature physically fast. This is hypothetical. I don't know if this is, but girls mature physically faster. So steroids for them at age 16 is okay, but for boys, it has to be 18.
Yeah. Like this is a case that it brings out a lot of my libertarian instincts. Because the government does have some broad role to play in like preventing quackery and like making sure that drugs but most of our medical decisions are not made with the government in the room. Like the way that the practice of medicine ordinarily works, and the way that it ordinarily works for children is that there are generally states have rules requiring informed consent, and they should. So the doctor has to explain to the child and the child's parents, here is the treatment I think you should take. Here are the benefits of this treatment. here are the risks of this treatment. I'm going to give you all the information I can give you about like why I think this is a good idea and why you may not want to do this. And then I am going to leave the room and you as a family have to make a choice. And I mean, that is how we do, if your child has leukemia, that is how a family decides whether that child is going to get chemotherapy. If a child has insert medical condition here, like virtually any, like the way that it works is that the government is not in the room. The government's role is to make sure that there is informed consent, to make sure that the doctor actually provides the family with the information it needs to make the choice. But then the parents and the child sit down and they make a decision with the information that they've been given. And what this case is about is whether gender dysphoria is different than any other medical condition that a child can have. I guess if I've got a kid with leukemia, I don't want the government in the room telling me that like my child can't have the appropriate treatment that my doctor's prescribed. I don't see why the rules should be different if that child has gender dysphoria.
I can see I'm a little bit less libertarian in that sense, in that, we have vaccine mandates, but what they cannot do is say your child is not eligible for this leukemia treatment because they're a girl.
Right. And that's where the constitutional issue comes up, is like, there's lots of bad laws that a state could pass. A state could probably ban chemotherapy tomorrow, so long as it banned it on an equal basis. And like, it would be a stupid law, but it would be constitutional. But once you start drawing lines on the basis of sex, that's when it becomes constitutionally dubious.
Okay. All right. So just with, I've held you for quite a while on this, but it's fascinating, obviously hugely important for the lives of many in this country. But let's talk briefly. There was a case about vaping. And the FDA, and correct me if I'm wrong in the summary, the FDA, it took a long time to basically, has responsibility for regulating tobacco and tobacco delivery mechanisms. It took a long time to do it. And by the time they did it, a lot of these products were already on the market. So they're now going back and saying, we've determined that fruity and sweet tasting tobacco products are not, on balance, are detrimental to public health, because while the ones that taste like tobacco, you can argue are a way of getting smokers to get off their cigarettes, the ones that taste like, banana splits or strawberries are really to get new smokers and new nicotine addicts into essentially the market. And so they started to ban those. Obviously the sellers of this are like, wait a second, we want to continue to make our profits based upon the societal expense of getting more people addicted to this stuff. And also maybe, who knows what other chemicals are in there, what it's doing to people's bodies. We won't know for another 25 years probably. But is that basically the case that we're looking at?
Yeah. So, let's take a further step back. So like, recreational use of tobacco has probably been around for thousands of years. It predates the U.S. Republic. Congress did not pass a law allowing the FDA to regulate tobacco until 2009. And so, like, by that point, tobacco products of all kinds were everywhere. Philip Morris is an enormous company. Like, the Congress decided in 2009 that we were finally going to give the FDA the ability to do something to try to mitigate the health effects of this drug that has been around for a really, 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 really long time. And then the FDA didn't decide until 2016 that it realized, oh God, there's this new technology, vaping. It's causing all kinds of problems too. So we want to make sure that we regulate this in a sensible way. What the 2009 law says is it says that whenever a new tobacco product emerges of any kind, in this case it's vaping, but it would be any new product, the FDA is required to ban it. And the statute's actually really clear. It does not say like you may ban it. It says you shall ban it. unless you can show that the product will cause more existing smokers to shift to less dangerous activity without also creating a bunch of new users of nicotine. So that's what the statute says. And the way that the FDA has interpreted that, which I think is very, very sensible, is they have said that, okay, when it comes to vapes, if you want to make a flavorless vape, we'll probably allow that. If you want to allow a vape that tastes like cigarettes, we'll allow that too. And the reason why is that vaping, while not safe, is believed to be safer than smoking. So if you can take people who are already smokers and you get them to switch to a vape, you have made the world better. You have made these people healthier because they're now using a less dangerous product. But the FDA has also said that if you make a vape that tastes like cherries, or that tastes like cotton candy, or that tastes like any kind of sweet flavors that are attractive to kids, that vape is illegal. And the reason why is because that product is not just going to be used by smokers who want to switch to something less dangerous. It is also going to be used by new vapors, by teenagers who think it's cool to have their milk and cookies flavored vape that they can suck on, and now they're addicted to nicotine.
Oh, believe me, I've had a middle school child already. I know.
Yeah.
Okay, and so this case is going to come down to that argument, I guess, as to whether, primarily that's where it's going to fall. But I'm curious in particular, and this may not be at play in this case, but we talked probably over the course of like the past 10 years, many times about the Chevron doctrine, which was a case where the Supreme Court found, and I believe it was in the mid-'80s, that executive agencies have a certain amount of latitude to determine how to essentially execute the law that has been passed by Congress, so that this law is the spirit of the law is maximized. And the irony was, it was Gorsuch's mom who was the head of the EPA when this case was brought, and it was people who wanted the EPA to do more than they were doing in terms of like environmental issues, and people who were arguing that they're not following the law, and the court at that time said, we're going to defer to the EPA.
Yeah.
And so when liberals, for lack of a better term, got in a position where they were in control of the EPA got more aggressive because liberals tend to want to protect the environment more at the cost of corporations. And this has been chipped away at and challenged until it was basically overturned, so that conservatives can say, no, there has to be something more specific. You need to take that sort of like ability to execute largely out of the hands of the EPA, or at the very least narrowed in terms of what their mandate is. So now that's where we are, and we're back to where we were in the mid-'80s, essentially, in terms of like, so how is that going to impact like the Trump agenda, et cetera, et cetera? Like, are we going to see a lot of like lawsuits brought by the left or people who are concerned with the administrative state not doing as much as they're supposed to?
Well, so the broader context here is that Congress passes all kinds of laws that like announce some sort of broad policy, but doesn't like provide an itemized list of here's all the ways that this statute will be executed, including when like new technology emerges that we've never heard of before, when new events arise that we couldn't possibly anticipate. And the question is, when you have a law that is ambiguous or that is being applied to a new situation, who should have the final word on how that law functions? And for many, many, many years, this is what Chevron said. the general rule is we want to defer to federal agencies. You know, we want to defer to the EPA on environmental matters. We want to defer to the FDA on questions about drug regulation. We want to defer to the Labor Department on questions about the workplace. And the reason why is because the Labor Department knows a whole lot of, well, there's two reasons why. One is that the Labor Department knows a whole lot about the workplace and the courts don't. And so if you take that power away from the Labor Department, you're likely to get worse decisions. But the other reason why is that we want to live in a democracy. And so like the issue in Chevron was that you had Gorsuch's mom, who was a conservative Republican, who was making decisions about like power plant regulation that some liberals didn't like. And I think what the Supreme Court appropriately said in the Chevron case is, look, we had an election. Ronald Reagan won. And like that has consequences. And so for the 4 to 8 years that Ronald Reagan gets to be president, he gets to, he and his appointees get to make these decisions. The flip side of that being when you have Barack Obama or Joe Biden in the White House, the same rules should apply.
And within a certain latitude, right? I mean, if Congress says we want there to be healthy skies, healthy air, if an agency finds that like actually, healthy is X number of milligrams of mercury in the air versus, Y number of milligrams of mercury in the air, if there's scientific backing for that, right? Like, I mean, that's the idea.
Yeah, like agencies have to comply with the statute. So like, an agency can't do something that the law doesn't allow it to do. But like, there are times when the law is ambiguous. There are times when the law just a new situation arises.
Right.
And the question is, should I be able to file a lawsuit and get the courts to cancel this decision the agency made that Congress has said the agency gets to make because I don't like the administration that made that decision? And Chevron essentially said the answer to that is no. I think that was correct. I like democracy, even if it hasn't performed very well in the month of November. But
arguably, there's a lot of other months too. But
at least
for another time. For another time.
Anyway, another time. But the broader context here is like when Chevron was handed down, Ronald Reagan was president. Republicans were ascendant. They were winning elections by landslides. And so Republicans loved the idea that power would be given to the president and his administration because they thought that the president would be their guy. And the minute the Obama coalition started being successful, and it looked like you were going to have, Democrats making a lot of consequential decisions at the same time that Republicans had a majority and then a supermajority on the Supreme Court, organizations like the Federalist Society started agitating, started trying to transfer more and more power away from the executive branch to the judiciary. And the reason why is because Republicans have a lock on the judiciary right now. So like, why would they want power some of the time when they can have power all of the time? So what does it have to do with the FDA case? Well, the FDA case, I think this case is going to be fine. Like the statute in this case is really, really clear. FDA didn't do anything wrong. There were several Republican justices, Justice Kavanaugh, Justice Barrett, even Gorsuch at one point signaled that like he didn't really think FDA. I think this case is going to be fine. But there was this lower court judge, Andy Oldham, on the Fifth Circuit. And if you know anything about the politics of the court,
we all talk about the Fifth Circuit. That's the one in Texas and Louisiana and is it Oklahoma? And this is where everybody goes to essentially get the craziest right-wing rulings.
Yeah, and if you read Oldham's opinion, Oldham's one of the craziest judges on this crazy court. It is just full of this anti-agency. He has this angry line about the bureaucrats and our fourth branch of government. Like he's trying to ride this anti-agency anti-agency sentiment within the Supreme Court to say that Andy Oldham, should get to decide what our policy is regarding vapes rather than the FDA. Now, I don't think the Supreme Court's going to go for that. I mean, the first Trump, like most of these regulations of vaping started under the first Trump administration. I don't know what we're going to get in the second Trump administration, but at least until very recently, there was a pretty broad bipartisan consensus that we don't want middle schoolers using nicotine. And so, like, I think that consensus probably still lives on the Supreme Court. Andy Oldham is an outlier. I think that, John, Brett, and Amy, or at least Brett and Amy, are probably going to look at this and say, like, yeah, I don't want my kid to be addicted to nicotine, and we'll be fine. But the broader context here is that this question of how much power should be held by the Republican judiciary and how much power should be held by federal agencies, which switch back and forth between both parties, is a very live debate. And Andy Oldham's position on this is that I should have all the power.
Interesting. Well, I guess we're going to we'll have more cases, I guess, where we'll see this. And it'll be lawsuits, I would imagine, brought by people on the left saying the EPA, the FDA, the USDA, the SEC are not adhering to the statutes as Congress wanted them. Ian Millhiser, senior correspondent at Vox. We'll link to your pieces on the Skrmetti case. Thanks so much for your time today. Really appreciate it.
Thanks, Sam.
Hey, folks, don't forget to hit the subscribe button and check out our daily show. We do it every day at 12 p.m. Eastern for about 2.5 hours. We even take phone calls. You should check that out.